okay with you,
Yeah.
as the appellant, same thing as normal. Take as much time as you need to get prepared, get composed, and then as soon as you start talking, I'll start the timer if that's okay.
If it pleases the court, my name is Beth Chalcraft and I will be appearing for the appellant, Mr. Lewison. I have two submissions to put to the court today. Firstly, the text message exchanges were sufficient to vary the contract, as the present case can be factually distinguished from MWB Business Exchange and Rock Advertising. And secondly, Mr. Lewison provided valuable consideration as he suffered a detriment due to Flash's failure to transfer him the coins on time. My lords, may I request to dispense with formal citations? Thank you.
Fine.
Unless your lordships have any questions at this stage, I will proceed with my first submission.
No questions, please proceed.
My first submission is in relation to whether the texts were sufficient to vary the contract. It is submitted that they were, on the basis that the present case can be factually distinguished from MWB on two grounds. Firstly, in MWB, the variation failed to mention the relevant clause, whereas in the present case, Miss Mays texted Mr. Lewison, ignore clause 4b. The importance of mentioning the relevant clause is demonstrated by Lord Sumption in MWB, as he states at paragraph 12 that one of the commercial reasons for enforcing such clauses is to prevent attempts to undermine written agreements by informal means. However, in the present case, the explicit mention of clause 4b indicates a clear intention to dispense with this clause. It is submitted that this reference demonstrates that the text message exchanges were not an attempt to undermine the contract informally, but rather a valid variation made with clause 4b in mind. Therefore, it is submitted that the clarity of this intention to dispense with the clause distinguishes the present case from MWB.
Could I just interrupt counsel slightly there? Obviously, we're dealing with a no oral modification clause. My concern is that if we say that the text message is sufficient, would we not be ignoring the original intention of the parties when they prepared and signed the written contract?
Thank you for your question, my lord. It is submitted that that is a misconceptualization of party intention and party autonomy. It is submitted that there is no valid reason why historical autonomy and intention of the parties should be given more weight than the present intention. This is because autonomy is inherent and inalienable. It does not become more important in the historical context than in the present.
Thank you.
Thank you. Secondly, the present case can be factually distinguished from MWB, as the variation in MWB was conducted via a phone call, whereas in the present case, the variation was conducted via a text message. It is submitted that in the present case, the text message was in writing and it was sufficient to fulfill the purpose of the signature. The purpose of the signature requirement is to verify the identity of the party signing. In the modern commercial context, text messages from known phone numbers are frequently regarded as valid confirmation of the sender's identity. In the present case, because Miss Mays and Mr. Lewison had a close relationship, they would have been familiar with each other's phone numbers. Communicating the variation via text message with each other was sufficient to fulfill the purpose of the signature requirement, as the parties would have known they were receiving messages directly from each other. I therefore ask the court to find that the text message exchanges met the requirements set out in clause 4b, and thereby find that Her Honour Judge Simpson was incorrect to hold that the text message exchange was insufficient to vary the contract. Unless your lordships have questions, I will continue.
Counsel, I have a quick question, if I may. Just to push slightly on the point of the signing, even if the court can accept a text as being in writing, your position is that being from the known number would constitute the identity and therefore a signature. Is that correct?
Thank you, my lord. Yes, that is correct. It is submitted that whilst it may be accepted, it is in writing, it should also be accepted by the court that it fulfilled the purposes of the signature requirement. Businesses should be given the opportunity to embrace technological developments, and therefore this is why the court should accept that a text message in the modern commercial context does fulfill the second requirement of clause 4b.
Thank you.
My second submission is in relation to the consideration issue. It is submitted that Mr. Lewison provided valuable consideration because he suffered a detriment by having to wait until the 15th of May for Flash to transfer him the coins. In Curry and Misa, Justice Lush stated at page 162 that a detriment suffered constitutes valuable consideration. It is submitted that Mr. Lewison suffered a detriment as a result of Flash's failure to transfer him 100 coins on time. If Flash had transferred him before the 15th of May, he would have had the chance to trade with these coins. As new coin had risen in value on the 8th of May, trading with these coins after the 8th would have been especially profitable for Mr. Lewison. As such, it is submitted that depriving Mr. Lewison of this trading opportunity constitutes a detriment for the purposes of establishing consideration. I therefore ask the court to find that Her Honour Judge Simpson was incorrect to find that Mr. Lewison did not provide consideration for the variation. Unless your lordships have questions, I will conclude my submissions.
No questions from me.
May I just question you just on the facts? Mm-hmm. So can you just walk me through which coin it was that your client was intending to purchase, followed by which one he wished to purchase, and which one actually increased in value in those times?
Thank you, my lord. The original contract on the 1st of May stipulated that Mr. Lewison was to be given 100 obiter coins. However, the text message variation stipulated that he wished to receive 100 new coin. It was the new coin that had risen in value on this date, on the 8th of May. And thereby, if the court accepts that the variation was valid, it is submitted that therefore he would have got the 100 new coin, and this is the coin that would have risen in value, and therefore if the first proposition is accepted, that would mean that he would have had the chance to trade with the new coin, which was of higher value from the 8th of May.
Thank you.
Thank you. My lords, it has been submitted that firstly, the text message exchanges were sufficient to vary the contract because of the explicit reference to clause 4b, as this demonstrates an intention to dispense with this clause, and because the receipt of a text from a known phone number fulfills the purpose of the signature requirement. And secondly, it has been submitted that Mr. Lewison did provide valuable consideration because of the detriment he suffered of not being able to trade his coins for many days. I therefore ask the court to find that Flash is in breach of contract and thereby allow the appeal. Unless your lordships have any further questions, I request to retire.
No further questions from me.
No further questions from me either. Thank you for your submissions.
Thank you very much.
Thank you. Thank you very much for that. I think we're now ready to hear from the respondent. So unless there's no further questions from any of the judges. Fantastic. The same thing applies to you. I'll hand over the floor to you. Take as much time as you need to get prepared as per usual, and then as soon as you're ready to get started, I'll start time.
If it pleases the court, my name is Varsha Kanadkar, and I'm appearing on behalf of the respondent, Flash Crypto Trading PLC. I would like to make two submissions to the court today. Firstly, that there was in fact no effective variation in contract following the exchange of texts between the appellant and respondent, and subsequently, even if there were effective variation, there is no good considerations so as to hold this varied contract to be enforceable. If your lordships have no further questions, may I proceed with my submissions?
Please.
Yes, please, counsel.
Thank you. For my first submission, I would like to direct your lordships' attention to Lord Sumption's judgment in Rock Advertising and MWB Business Exchange Centres Limited. As my learned friend rightly pointed out, Lord Sumption did in fact hold no oral variation clauses to be effective on the caveat that there is an unequivocal representation that there is a material change in the intentions of the parties to depart from such a no oral variation clause. I would like to submit to the court today that it would be in fact contradictory to the fundamental principle of freedom of contract, so as to not hold clause 4b in the instant case to be effective, as there was no such unequivocal representation for the purposes of showing this material change in intention. For this, I would like to firstly refer to one of the primary reasons for Lord Sumption's judgment, which is a factual analogy to the present case at hand. Per Lord Sumption, it is essential to hold such no oral variation clauses to be effective, so as to ensure that there is a method of policing internal authority within large corporations such as the respondent. This is exemplified by the fact that Ms. Mays, in her authority as Deputy Head of Trading, in fact, purported to make a change in contract, which in fact the head of trading was unaware of, and which led to the current conflict whereby there was a completed transaction that was not in line with what the appellant expected. This mismatch between the deputy head of trading and head of trading is something that would have been avoided on the basis of the original intention of the parties to ensure that all variations of contract are in fact in writing and signed by parties, so as to ensure internal consistency and high levels of regulation for sensitive matters such as cryptocurrency trading, which is essential in my mind, as I would like to submit to this court, in ensuring that there is legal certainty for such trading. Whilst my learned friend may suggest that the good rapport between the appellant and Ms. Mays in this case makes it appropriate for any effective contractual variations to occur by the means of text messages, I would like to in fact submit that these text messages are in operation outside the ambit of Ms. Mays as Deputy Head of Trading. The current factual matrix shows that in fact Ms. Mays and the appellant engaged in numerous conversations about their respective trades, but it would be incorrect to hold that Ms. Mays had these conversations in her position as Deputy Head of Trading and rather simply as a friend of the appellant. And so it would be I would like to invite this court to not find in favor of these text messages being unequivocal representations of a person with ostensible authority to make such contractual variations. Additionally, I would like to submit that it is in fact necessary to remember that the law does not protect commercial parties from bad bargains, as it is clear from this case. In the original contract, one of the primary stipulations was that the contract would not be sensitive to any fluctuations in currency. The appellant in this case clearly gave his electronic signature to this clause with the intention that there would in fact be no such fluctuation. Upon such a fluctuation happening, the appellant attempted to reduce their losses, which is fundamentally contradictory to the intention of the original contract. And as such, I would like to invite the court to find in favor of the appellant with regard to the respondent with regards to the fact that there was in fact no contractual variation on the basis of this being a fundamental contradiction to the original contract. If your lordships have no further questions, I would like to proceed to my second submission.
I'm very interested to hear about the issue of consideration, because I have some questions that I'd like to put to counsel on that issue. Bradley, is there anything you'd like to ask on the issue of the contract itself and the variation?
I'm interested to know actually that one point you make, counsel, regarding it being two commercial parties. And is it your stance that in such a situation there should be less leniency from the court?
Thank you for your question, my lord. In fact, I do agree that there should be less leniency. This is in particularly not with respect to the appellant as an individual trader, but rather to the respondent as a large corporation, so as to maintain internal coherency for their regulations and ensuring overall consistency in terms of their practice as cryptocurrency trading.
Thank you, because you picked up there on the point that I was really considering, of course, that on the one hand, we do have a consumer. So however we may have expected your large commercial party to act may not have been how we expected the other party to act. Thank you very much for answering the question.
Thank you, my lord. I would like to now proceed to my second submission. And for this, I would suggest to the court that even if there was effective variation in the contract, there is no good consideration on the basis that following the varied contract, there is no fresh consideration provided so as to make the varied contract enforceable. Whilst my learned friend referred to the detriment suffered by the appellant by the respondent not making the trade on the stipulated date of 1st of May, this would equally not hold true to be consideration for the varied contract. As per the principle of Stilk and Myrick, it is necessary for there to be fresh consideration upon a variation of contract. So whilst there was a detriment suffered initially on the basis of the trade not happening on the stipulated date, there can be found no fresh consideration upon 8th of May, when in fact the exchange of texts took place between the appellant and the respondent. And for this, I would also like to subsequently suggest that it is very clear from the factual matrix that the variation in contract in fact took place upon the basis of a practical benefit perceived by Ms. Mays in her view of the appellant as a valued customer. It has been made sufficiently clear that while the case of Williams and Roffey Bros and Nichols suggests that practical benefits such as maintaining a good relationship with your valuable customers would provide fresh consideration for the purposes of enforceable contracts, it is equally necessary for this court to note that the case of Reselect Move subsequently made sure that this principle of practical benefits is sufficiently curbed, and it is necessary to recognize that there was in fact no independent legal benefit obtained by this variation in contract so as to constitute fresh consideration for the purposes of a new and varied contract. If your lordships have no further questions, I would like to conclude my submissions.
Thank you for your submissions, counsel. I'm interested to go back to this point on the Williams and Roffey case, because certainly from my understanding of that judgment, there's quite a significant judicial discretion as to what can constitute a practical benefit, and also to the sorts of situations that it can apply to. I'd just like to hear a little bit more about why you think that principle of practical benefit shouldn't be considered in this case, or that the practical benefit itself either doesn't exist or that it should be outweighed by some other factor, because to me it seems that there is quite wide discretion on that point.
Thank you, my lord, for this question. I entirely agree with you on the point that there is in fact a wide judicial discretion afforded to the concept of practical benefits, and this in fact is the core issue in the particular factual matrix of this case. If we are to allow a vague concept of a valued customer and protecting business relationships with that customer to constitute valid consideration on the basis of it being a practical benefit, the issue I would like to point out is this would be essentially creating a differentiation between customers for a large corporation such as flash crypto trading. This in fact is problematic, as it will pose a question of for what I would like to quote as the floodgates argument, whereby if we were to allow the practical benefit in this case to be recognized as fresh consideration, the respondent would be potentially opening itself to further claims by numerous other customers on the basis of all renegotiations that took place on the basis of personal relationships they have with respective employees in the respondent's company. And on the basis of this, it has also been made clear by the case of Rock Advertising and MWB Business Exchange Centers, whereby the court reverted back to the principle of Folks and Beer. They believe that it exemplifies the fact that Folks and Beer is in fact the applicable case in such circumstances, and it has been made clear that the wide judicial discretion afforded to the principle in Williams and Roffey Bros and Nichols is in fact not considered to be effective and good law.
Okay. Thank you for answering that question, counsel. It's helpful.
Thank you. On this basis, I would like to conclude my submissions and invite this court to hold in favor of the appellant on firstly the basis that there is in fact no effective variation in contract, and subsequently that there is no fresh consideration provided in this varied contract so as to make it enforceable. Thank you.